College, Mumbai. Great delight to introduce to you our awareness program, AZADI 75, which is the celebration of 75 years of the establishment of the Constituent Assembly and the Platinum Jubilee of the Indian Independence. Government Law College, in its splendid history that spans 166 years to this date, has not only witnessed the Indian freedom struggle very closely, but also participated in achieving Indian independence. The college has also witnessed the making of our constitution from the very day of the establishment of the Constituent Assembly, and hence the celebration of Indian independence is very close to our hearts. I request all members to kindly mute themselves. Azadi 75 is the brainchild of our principal, Dr. Asmita Vaidya, and under her leadership, we will be organizing 75 diverse activities throughout the year, commencing from 15th August 2021 to 26 January 2022. Today's session will be on child labor laws and regulations in India, presented to the students of Lala Lajpat Rai College of Commerce and Economics, Mumbai. To begin with this program, I request for the Saraswati Vandana, an ode to the goddess of knowledge, to be played.
ब्रह्माच्युत शंकर प्रभृतिभिः देवैः सदा वन्दिता सा मां पातु सरस्वती भगवती निःशेषजाड्यापहा.
Before we begin this program, I request, I would like to request our principal, Dr. Asmita Vaidya, to say a few words.
Ma Saraswati Lavandan. Very good afternoon to all the students of Lala Lajpat Rai College of Commerce and Economics, Mumbai, and all my beloved students. Special greetings and thanks to Honorable Director Neelam Madam and Coordinator Meenam Saxena Madam of Lala Lajpat Rai College. Friends, as has been narrated earlier, this year our college is celebrating AZADI 75 in view of completion of 75 years for the establishment of Constituent Assembly. The members of this assembly took a lot of efforts to frame and draft our constitution, and thus it became the ideal constitution. They took efforts to draft this constitution at least 3.5 years, and we got Constitution of India. The main purpose of conducting 75 programs under AZADI 75 by the students and the staff of Government Law College, Mumbai is to communicate the fundamental rights and fundamental duties to the younger generation in the perfect way. You all are mature and more than 18 years. So you have many rights. But what rights do you have? Are you aware of? Yes, might be few of them, like voting rights, and right to education. But you have many more rights, fundamental rights, such as right to equality, right to life, right to breathe, pollution-free air, right to move, freedom of speech and expression, right against exploitation, right to freedom of religion and culture, right to property, and so on. Fundamental rights are a group of rights that have been recognized by high degree of protection from encroachment, and therefore they are special rights. Similarly, we all are supposed to follow the fundamental duties. We all are abide by the Constitution and must respect national flag and national anthem. We all must follow ideals of freedom struggle. We all must protect sovereignty and integrity of India. We must defend the country and render national services when called for. We must have spirit of common brotherhood, and we must preserve as composite culture. Friends, today my students are going to focus on child labor and rights regarding it, regulations regarding it. Article 24 of the Constitution clearly states that no child below the age of 14 years shall be employed to work in any factory or mine or employed in any of the hazardous employment. And based on this principle, we have the Child Labor Prohibition and Regulation Act 1986 and the recent one, Child and Adolescent Labor Prohibition and Regulation Amendment Act 2016. As per this act, child is defined as a person below 14, as we all know, and adolescent means a child or the children coming under 14 to 18. And they are not allowed to work as a domestic help also. Even adolescent children, they are somewhere allowed to work with exceptions. As a citizen of India and as a youth of the country, we all should be aware of our rights, our duties, and also rights of our family members and other members of the society. With that intention, we are going with such program called AZADI 75. I'm thankful to Lala Lajpat Rai College for giving us this opportunity to have a legal words with the students. And today is a special day. It is a death anniversary and Punyatithi of Lala Lajpat Rai, who was an Indian independence activist. He played a very important role, a pivotal role in independence movement. He was popularly known as we all know, Punjab Kesari. इस महान व्यक्ति को अभिवादन करती हूँ और मेरे शब्दों को विराम देती हूँ. I express gratitude towards the college and thank you for cooperation to all my students. Thank you very much.
Thank you, ma'am. Without further ado, I would like to invite our students to begin with the presentation. In case any student has any queries, you can drop in your questions in the chat box. Thank you.
Good afternoon, everyone. I hope I'm audible. Okay.
Yes.
Thank you all for joining us. As a team, we hope that we are able to help the aim of this program and contribute in spreading the awareness about child provisions under the Constitution for child rights and the recent amendment that has been made to the child labor laws in our country. Before beginning with the constitutional provision and with the main aim of the program, I would first like to give a brief on the importance of the Constitution. To give a brief about the Constitution of India is the supreme law of our country, and it lays down the framework that demarcates the fundamental political code, the structure, procedures, powers, duties of various government institutions, and most importantly, sets out the fundamental rights, directive principles, and the duties for all of us, that is, the citizen of the country. Now, child rights have also found its due place in the fundamental rights enlisted in the Constitution. India has had a long history of slavery, exploitation, and ill treatment. When India got its independence, it was thought imperative for the framers of the Constitution to give due regard to the welfare of children in India in the background of severe exploitation at hand of industrialists and the society in general. With this background and taking in point to the aim of the present program, we'll be discussing two things in the present program. The first is the constitutional provision for upliftment of child upliftment. And second, the amendment that has been made to the Child Labor Prohibition and Regulation Act 2016. To get onto the articles that have been framed under the Constitution of India, the first article and the important article is Article 24 of the Constitution. Article 24 of the Constitution basically prohibits the employment of children below the age of 14 in factories, mines, or any other hazardous employment. Can the slide be shifted to the next slide, please? Thank you. Just to read Article 24 for everyone present here. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. This article absolutely prohibits employment of children in any factory or any hazardous industry, mines, or mines. It does not even allow any exception, although it is implicit that children to work in non-hazardous industries such as a domestic work. However, which is already pointed, the new change or the new amendment that has been made, which was already pointed out by a respected principal, even domestic work is not allowed for children before the age of 14 years. And the same will be elaborated upon by the other team members during the course of the presentation. Now, child labor is a bane for the nation. It is a shameful practice which harms the welfare and development of children as well as the entire nation. It is important keeping the background in mind and the history of India and everything that children had to go through, majorly in the industries or by the hands of the industrialists or the society in general. The other article or the other article that is included in the Constitution is Article 39. Now, the basic difference between Article 39 and Article 24 that I already elaborated upon right now is that Article 24 is a fundamental right under the Constitution, whereas Article 39 is a directive principle of state policy. Now, it is important to know the difference to understand what is the effect that Article 39 has on India and the people of India. So a directive principle of state policy is different from fundamental right, and the basic difference being that it's not enforceable in the courts. However, it is still a very important consideration for the legislators of India when they are framing rules or laws for the welfare and development of India. So Article 39 is definitely something that has to be taken into consideration by the framers or the legislators. However, it's not enforceable. With this background, I would like to state what the relevant provision of Article 39. So Article 39E states that the health and strength of workers, men and women, and the tender age of children should not be forced by economic necessity to enter into any vocation unsuited to their age or strength. And Article 39 basically follows that due to economic necessity, no child of tender age must be forced into any work which is hazardous for their health or for their physical or mental health. Now, this is again important in the context that has already been laid down by me during the start of the presentation. To streamline that it's obviously not healthy for anyone, and especially child with an adolescent age who must be in a position to see the beauty of life and just grow and be nurtured in a proper environment, be educated. Now, these are the things, taking into consideration all these things and the background, Article 24 and 39, when read together, give out some of the important features. That is basically that they prohibit any employment of children under the age of 14 in any hazardous work or any work which is unsuited to the age they are at. Then it ensures safety and healthy life for children, and it imposes a duty on the state to ensure that children are not abused or forced to work in harmful places because of financial problems. It is still horrifying to know that India still has child laborers, and it was only due to this that there were several provisions that were made, or there were several legislations that were passed, taking in pursuant to Article 24 and 39 to save children from child labor. Some of the provisions are the Employment of Children Act, that basically prohibits employment of children under the age of 14 in railways and other means of transport. Then the other important legislation being the child labor law, that is the Principal Act, under which the 2016 amendment that we will talk about in the due course of the presentation has been made. And the Child Labor Prohibition and Regulation Act basically prohibits engagement of children in certain employments and regulates the rules or regulation that must be taken care of while children are being employed in in any work. Then there are more acts that essentially prohibit the involvement of children in beedi making, mines, power looms, automobile workshops, cracker productions, and other factories which would be hazardous or would fall under the nature or the scope of hazardous workspace for children. Further, there is Article 21A that will be taken up by my team member. And yes, over to Anjali.
Am I audible? Okay. Good afternoon, Anjali. Thank you, ma'am. Good afternoon, everyone. Thank you, Abhirtana, for that presentation. I'm Anjali, and I'll be presenting on fundamental right to education as guaranteed under Article 21A of the Constitution of India. A little bit background before delving into the details of Article 21A. Originally, Part 4 of Indian Constitution, that is Article 45 and Article 39 of Directive Principles of State Policy, had a provision for state-funded as well as equitable and accessible education. The right to education was initially not included as a fundamental right in the Constitution and was included as a directive principle under Article 45, which required the state to provide, within a period of 10 years from the commencement of the Constitution, for free and compulsory education for all children until they complete the age of 14 years. However, since the directive principles were not enforceable, right to education took a backseat. Education is a fundamental human right and essential for the exercise of all other human rights. It promotes individual freedom and empowerment and yields important developmental benefits. Yet, millions of children and adults remain deprived of education opportunities, many as a result of poverty. India is home to 19% of world's children. What this means is that India has the world's largest number of youngsters. However, the not so good news is that India also has 1/3 of the world's illiterate population. It is not as though literacy levels have not increased, but rather that the rate of the increase is rapidly slowing. To combat this worrisome trend, the Indian government proposed the right to free and compulsory education, making the education a fundamental right. The Constitution's 86th Amendment Act inserted Article 21A in the Constitution of India to provide free and compulsory education to all children in the age group of 6 to 14 years as a fundamental right. The Right to Children to Free and Compulsory Education Act, which is also known as RTE Act 2009, which represents the consequential legislation envisaged under Article 21A, means that every child has a right to full-time elementary education of satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. With this, India has moved forward to a right-based framework that casts legal obligations on the central and state government to implement this fundamental child right as enshrined in Article 21A of the Constitution in accordance with the provision of the RTE Act. Could we please move to the next slide? The RTE Act provides for the right of children to free and compulsory education till completion of elementary education in a neighborhood school. It clarifies that compulsory education means obligation of the appropriate government to provide free elementary education and ensure compulsory admission, attendance, and completion of elementary education to every child in the 6 to 14 age group. Free, on the other hand, means that no child shall be liable to pay any kind of fee or charges or expenses which may prevent him or her from pursuing and completing elementary education. It makes provision for a non-admitted child to be admitted to an age-appropriate class. The Act also mandates 25% reservation for disadvantaged section of the society, where disadvantaged groups include the SCs, STs, social backward class, and differently able section of the society. Next slide, please. It lays down the norms and standards relating to pupil-teacher ratios, buildings and infrastructure, school working days, teacher working hours. It provides for rational deployment of teachers by ensuring that specified pupil-teacher ratio is maintained for each school rather than just an average for the state or district or block, thus ensuring that there is no urban-rural imbalance in teacher posting. It also provides for prohibition of deployment of teachers for non-educational works other than some few things which includes elections to local authorities and disaster relief management programs, etc. It provides for appointment of appropriately trained teachers, that is teachers with the requisite entry and academic qualification. It also provides that no child shall be held back, expelled, or required to pass a board examination until the completion of elementary education. A certificate will be awarded to a child who will complete his or her elementary education. Moreover, it also prohibits physical punishment and mental harassment, screening procedures for admission of children, capitation fee, private tuitions by teachers, and running of schools without recognition. It provides for development of curriculum in consonance with the values enshrined in the Constitution and which would ensure the all-round development of the child, building on the child's knowledge, talent, and making the child free of fear, trauma, anxiety through a system of child-friendly and child-centered learning. Next slide. Now talking about the achievements of Right to Education Act 2009, the Right to Education Act successfully managed to increase enrollment in the upper primary level, that is classes 6 to 8. Stricter infrastructure norms has resulted in improved school infrastructure, especially in rural areas. More than 3.3 million students secured admission under 25% quota norm under the Right to Education Act. It made education inclusive and accessible nationwide. Removal of no detention policy has brought accountability in the elementary education system. Therefore, it is for the first time in the history of India that we have made this right enforceable by putting it under Chapter 3 of the Constitution of India as Article 21A. This entitles children to have the right to education enforced as a fundamental right. However, it should be noted that it has been 12 years since the implementation of the Right to Education Act, but it can still be seen that it has a long way to go to be called successful in its purpose. Creation of conducive atmosphere and supply of resources would pave the way for a better future for individuals as well as the nation as whole. Some of the suggestions that could be made would include more focus on teacher training programs. Quality of education needs to be emphasized over quantity of education. Steps should be taken to make teaching profession attractive. Society as a whole needs to be supportive of education for children without biases. This brings me to the end of my presentation, and I would now like to hand over to Ms. Ira Gosavi to present on Child Labour Act. Thank you, everyone.
Good afternoon, everybody. I hope that I'm both audible and visible.
Yes,
Okay.
yes.
Thank you so much. So what I'm going to speak about today, essentially, is the Child Labor Prohibition and Regulation Act, which was passed in 1986. And recently, there were a few amendments that were made to it as well, but that would be spoken about by the next speaker. So there are two main objectives of this act. The first one was to lay down a procedure in law to decide which employments and which occupations should allow children to be employed in the first place, or should not allow, and in which occupation should they not be allowed to be employed. And secondly, even in those occupations in which children were allowed to be employed, the regulations and all of the procedure for the regulations within those were essentially laid down in this act. What this act really did was combine together all of the different regulations and standards that were laid down in different kinds of acts, and provided a uniform set of rules and regulations within which there was a uniform set of standards and prohibitions that were laid down in cases of employment, etc. There were five main features of this act, rather. The first one was to ban the employment of children below the age of 14 years in specific occupations and processes. The second one was to lay down a procedure to decide modifications to the schedule in which all of these banned occupations were mentioned. Thirdly, it was to regulate the conditions of work of children in employments where they are not prohibited from working. Fourthly, to lay down a procedure to punish those individuals who violate this act. And fifthly, to really define who a child is so that there's a uniform and standard definition that can be applied through all of the different laws as well. What this act also did was set up a committee called as the Child Labor Technical Advisory Committee, which would advise the central government if at all they had to make any sort of amendments, etc., in the future, or if they were to add or subtract any occupations in which children were banned to be employed in the future. So let's look at the features in a nutshell. As I mentioned earlier, the Act provides about 13 occupations and 15 processes in which children can be employed. So children below the age of 14 years cannot be employed, and all of them have been listed in detail. And I would just list out a few, for example. I think, for instance, the occupations which involve work related to on a railway station or any other work in which children would have to work in really close proximity of a station or railway line. Cinder picking or clearing of an ash pit in railway premises. Work which involves the selling of firecrackers or fireworks, or even in the manufacturing of those, working in slaughterhouses, or processes that require children to be or carpet weaving or manufacturing some items, cleaning wool, manufacturing cement, etc. The idea is that all of these occupations are extremely hazardous, very, very dangerous for especially young children to be working in. because of which this act lists down a number of those, and students cannot really, children cannot be employed in any of these whatsoever. Other than laying down the areas in which you cannot be employed in as a child below 14 years, what this act also does is lay down certain conditions which really regulate the kind of hours and period that you work in. Because more often than not, what happens is that even if the factory or industry that a child is employed in is not extremely hazardous or dangerous, often employers can make children work for really long periods and for really long hours, which can be really detrimental to their health, and this also takes a toll on their education, etc. And especially in the context of in a country like India, wherein there is a large amount of poverty and unemployment, children are often expected to earn a living for their families, and their families themselves expect them to work long hours so that they get some money at home. So this actually lays down certain regulations in which employers cannot exploit children within working hours. So what it says is that a child cannot work for more than 3 hours at a stretch, and at a maximum, after a maximum of 3 hours, they have to be given a rest break for at least an hour. And even after that, they can only work for 3 more hours. So if at all you have to work, it can be only for a maximum of 6 hours with a 1 hour break in the middle. And then it also says that a child cannot be employed within 7 p.m. to 8 a.m. on the next day. They also can't be forced to work overtime, and they cannot be forced to work at 2 places at once. They necessarily just have to work at one place at a time. And even within that one place, they have to have these intervals, etc. Other than that, within these premises, the government is empowered to make rules with respect to the kind of cleanliness that industry or factory has to follow, or the way that waste can be disposed of, or the amount of dust or lighting, or the precautionary measures that they have to take in a certain building. All of this is really regulated. So the government is empowered to make such rules in order to make sure that the place that these children are working in is well ventilated, that's not really stuffy, or there isn't a lot of pollution, or it's not dirty and dusty either, and they have decent working conditions as well, so that the health and the safety of these children is then ensured. And then lastly, it also lays down punishment who violate the rules which are given in the Act. So essentially, it has to be, the punishment as laid down in the Act is for a minimum of 3 months. It can extend to a year, and there can be a fine between 3,000 to 20,000 rupees imposed as well. So it was one of the first legislations in India which really made the child regulations uniform, in the sense that previously you had to refer to various different acts which might or might not have regulations for children, but this laid down a comprehensive, uniform piece of legislation for where children could be given occupation, and where they, and the kind of working conditions that they could live under. And I think Kevin is now going to speak about the amendments and what they brought. Thank you.
Thank you, Ira. I hope I'm audible again. Okay, yeah. Thank you for the confirmation. So as of now, just to give a brief purview of all that has happened, we've had Abhyarthana and Anjali talk about how the Constitution provides for the protection of children. We also saw how initially there were certain directive principles. They were not enforceable, they were only DPSPs. Then we progressed on to enforceable rights, things that are guaranteed under the Constitution. After which Ira has spoken about the first major provision that we had in law, which was the provision of 1986. And after that, in 2016, we have had an amendment. So there has been a constant stream of improvement, one after the other. And as Anjali said, that there is still a long way to go. But what we are talking about today is the few things that the central government has done up until now, and how in its own way it has helped the children. So in 2016, India's central legislature made the amendment to the 1986 Act. So this was called as the Child and Adolescent Labor Act of 1986. The reason why that has happened is because they have added a new stakeholder as well, because the Amendment Act also speaks about adolescent children, as respected principal mentioned, that adolescent children are those who are from the age of 14 years to 18 years. They are also covered and protected under this new amendment. So I'll just talk about a few basic provisions about this amendment. Abhyarthana, if you could move to the next page. Thank you. So in essence, what this has done is taken a higher burden. A complete prohibition has happened on employing any child below the age of 14 years in any establishment. There is no distinction between hazardous or non-hazardous. Irrespective of that, there is a complete ban. But there is also a practical consideration that has come about in this act. As you can see, that a child is permitted to work to help family enterprise or family. So this provision acts more on your professional capacity, in the sense you should not be working outside of your family if you're under the age of 14. But if it's within the family, for practical considerations and reasons, it has not been prohibited or stopped. So children are in essence allowed to still help out in their family establishments. And as I said before, the concept of adolescent labor has also been brought into the picture, because it's not just enough that you protect and try and save children who are below 14 years. Even 14 to 18 years is where people can still be considered to be small. They are still young. That is why this protection becomes extremely important. And this amendment is very crucial in that aspect, because it also introduces adolescent labor and how they are protected. So I'll speak about now the other provisions one by one, which are the salient features of this act, which are the few broad things that this act aims to cover. The first is, like I said, that there has been a complete ban. The 1986 Act prohibited employment under 14 years in certain occupations. Like I said, if it's mines, domestic work, the risky or hazardous activities that Ira spoke about, in those instances, they were banned. But what the 2016 amendment has done is that all instances, wherever a child is below 14 years, whether it is hazardous, such as mines or power looms, or non-hazardous, both of them are banned, because the age is so young that it doesn't matter if it is hazardous or non-hazardous. The protection has to be extended to everyone. So the first salient feature you will see is that the protection given by the Act has been increased and broadened to include more children and more capacities and more professions, which ensures a higher level of protection to these younger children. The next salient feature, which is the second aspect, is the definition of adolescence. So it defines children between the age of 14 to 18 years as adolescent, and it bans their employment in hazardous occupations. Now, the question you may have is, what is a hazardous occupation? Because that has to be defined. The definition of a hazardous occupation is crucial, because you don't want people getting away on technicalities because of ambiguity of law. So the 2016 amendment defined this term hazardous occupation in a schedule towards the end. They defined this hazardous occupation to mean occupations where there are mines, where there are inflammable substances, or where there are hazardous processes. So if you remember what Ira had mentioned, she had spoken about how those professions in the 1986 Act, mines were prohibited, power looms were prohibited. So similarly, in the 2016 Amendment Act, a hazardous occupation has been firstly defined to include processes that involve mines and inflammable substances or explosives. We often see during Diwali how there is much debate about firecrackers and how children are the ones who are made to be manufacturing these firecrackers. So this new act tries and protects not just 14-year-olds, but also children from 14 to 18 who may otherwise have been forced to work in those dangerous conditions. Now, the third definition of hazardous occupation is the term hazardous process. And the definition of hazardous process is being taken from another act, which is the Factory Act of 1948. And it is slightly technical, but just to give a brief overview of what a hazardous process is, it would be anything which could possibly have raw materials or finished products that may cause a material harm to the health of a person or may result in the pollution of the environment. So as a general thumb rule, like I said, 14 to 18-year-olds are protected from working in places which have mines, which have inflammable substances, and those places which have processes or machines or fumes that may harm their health or the health of the environment in general. So again, the general theme of this act is how the protection has been broadened and increased to include more people and more professions. So that is the second salient feature. I'll now move on to the third one. Abhyarthana, if you could scroll down to the next page. Thank you. So the third salient feature is that this act makes child labor a cognizable offense. What is a cognizable offense? In simple terms, a cognizable offense is one where a police officer can make an arrest without requiring a warrant. Only those offenses which are considered to be serious in nature are given the tag of a cognizable offense. So this is yet again another step where you are understanding the seriousness. If you remember, Abhyarthana had given statistics and mentioned that child labor is a bane, that it harms the youngsters of our generation and will also hamper the extent to which a country can develop as the time goes by. To acknowledge the extent of that evil, it is crucial to understand why it's called a cognizable offense, which means arrest can be made without waiting for a warrant, without having to wait for the red tapeism, if at all it does happen, and then due process can follow, which allows for quicker justice to be rendered when needed. And then the third salient feature, as I'm speaking about, talks about the punishment that can be given if in case someone is found to be in breach. If you're employing a child below 14 years, then you will get a jail term or a fine or both. The jail term can be between 6 months to 2 years, and the courts will decide how much duration they want. Similarly, a fine can be between 20,000 rupees to 50,000 rupees, and in certain instances, both can be given. And this is for people who are breaching the act or violating the law for the first time. But those who are repeat offenders or who do it multiple times after the first time, the provisions are stricter naturally. So the punishment or imprisonment is between 1 to 3 years. And in case if the offender is a parent, they have created another caveat where a fine of 10,000 rupees has been created and envisaged. So this third salient feature talks about the extent of importance, that is the cognizable offense that they have given it, and the punishment which is given in case of a breach. The next aspect is few brief salient features, which are the fourth and fifth ones. So the fourth salient feature is that the Act has provided for a rehabilitation fund for the rehabilitation of children. And I'll speak about the fifth one also, because both of them in cumulation, you'll realize how there's a common theme. The fourth one talks about a rehabilitation center. And the fifth one talks about how the definition of hazardous occupation has been reduced. There is a lot of debate about this particular step as to how people believe that the definition should not have been reduced and more occupations should have been deemed to be hazardous. But that is something probably over time we'll realize what exactly was the intention of doing this. But the next aspect within this salient features you'll see is that it empowers the union government to add or omit any hazardous occupation as the time goes by. So if you see, the common theme in this is that this rehabilitation is a good step in the right direction. Often legislations and laws do one aspect of justice, wherein they punish the wrongdoer. But the second aspect of justice is also to ensure that the victim of the wrongdoing is also rehabilitated and taken care of. So this salient feature, which provides for the rehabilitation funds, which will provide for resources, could be physical therapy, mental therapy, and other such aspects of rehabilitation, is very important. Because for those children, and if you remember again, all the speakers before me have mentioned that the reason why child labor is such an evil is because children who are forced to go through child labor and forced to work in dangerous circumstances are unable to develop properly because they have physical impairments, mental impairments. There's a lot of trauma there. So simply punishing the wrongdoer isn't enough. You also need to ensure that these children are able to then grow properly and become proper functional adults. Which is why the rehabilitation fund comes as a crucial measure where you're able to envisage that. And it's a good step. The next aspect is the sixth and seventh, the last aspect of salient features that I have with me currently. The first is that it empowers the government to have periodic inspection of places at which the employment is prohibited. Again, a fairly intuitive step where this periodic inspection ensures that from time to time, people are constantly following the rules. Simply having a law in itself is not always sufficient. The implementation also becomes crucial. That is why often one of the concerns that people have when it comes to serious offenses is that the law says one thing, but the implementation of the laws doesn't ensure that thing. But if you see these two salient features, which is F and G, both of them are steps towards implementation. So in F, you see that you have constant inspections that go on in different places, which will ensure people are abiding by the law. And in G, you will see that the government may confer powers on a district magistrate to ensure that the provisions of law are carried out. So again, you are involving the judiciary into this implementation and ensuring that on the ground level, the implementation happens as and when the person empowered deems fit to act and enact the provision. So just to conclude, again, to set up a timeline, we have seen some progress over the years. We have seen how the central government has taken child labor prevention from a directive principle to an enforceable right to an act which has been amended and made broader and larger in scope of the protection it provides. There is still a long way to go, and I think Yashasvi will also be talking about how there are current challenges that we face, but we are still en route. So that is a good sign, and all these salient features do provide for higher protection and better implementation. So hopefully in the future, we don't need to be speaking about this in a negative term whatsoever. That's it from my side. Thank you for a kind and patient hearing. I'll hand over the mic to Yashasvi now.
Hello, I would just like to confirm that I'm audible.
Yes.
Thank you. So since we are already well versed with the various legislative provisions that my peers have so kindly explained, concluding, I would like to highlight the current plight of children in India. So the condition of working children and children in forced and bonded labor in the country has always been concerning, but the pandemic has likely pushed more children into child labor. So the pandemic triggered a massive increase in the cases of abuse and violation faced by children in India. The condition of working children and children in forced or bonded labor in the country has only worsened in the face of the COVID-19 pandemic. A report by the International Labour Organization and UNICEF has warned us that about 9 million additional children are at the risk of being pushed into child labor by the end of 2022 globally. And this is a result of the pandemic. In India, especially since schools were closed down and the economic crisis was triggered due to the pandemic, vulnerable families are pushing children into poverty and thus child labor and then consequently unsafe migration. So even before the pandemic, as the speakers before me had pointed out, many children were already quite vulnerable. And there has been some progress in reducing the child labor cases, but this progress has only been reversed by the pandemic. In 2016, the government estimated that there are over 100 million migrant workers, of which about 20 to 25% are children. So with over 1.5 million schools closed during the course of the pandemic, the opportunities for marginalized children to engage in meaningful developmental activities, such as educating themselves, have also gone away or reduced significantly. Despite legislative provisions and policies against child labor in India, the country is grappling with the worsening of the situation of child labor. Children's access to education, basic nutrition, and other critical requirements for their development and well-being have suffered a huge setback, and many new children have fallen into the trap of forced labor, along with further deteriorated conditions for the existing child laborers. So how can we help, and how can our government help, right? Apart from the already existing legislative provisions, what is it that can be done by the citizens or by other NGOs? So the first thing that should be done is to report cases of child labor. Compared to the actual number of child labor cases, the number of complaints made and FIRs filed remain quite low in India. And what can be done is that nonprofits and other civil society organizations that care about children's rights can take up the mantle of making as many complaints about child labor as possible. So how that happens is that any complaint related to child labor can be made directly to authorities such as a district collector or via a child helpline, which is the number 1098, or on a government portal, which is called Pencil, that is PENCIL, or through statutory bodies such as the National or State Commissions for Protection of Child Rights or Child Welfare Committee, which is called a CWC. What will happen is if there are a large number of complaints, it will also allow nonprofits and these societies to make stronger appeals to administrations to strengthen rescue processes and implement the already existing laws. The next thing that can be done is carry out rescue operations. So these rescue operations would involve all activities associated with organizing inspections and raids for the identification, establishment, and withdrawal of child labor engaged in prohibited work as specified under the laws that Ira had explained to you. What these rescue operations then aim to do is to rehabilitate and integrate these children into society again so that they can focus on their own development and they can focus on education so as to make better citizens out of themselves, so as to make a life for themselves. These rescue operations include rescuing both individual childs or several children, and it is taken up by the Ministry of Labor and Employment. So what happens after these children are rescued is what is something that would take this country a long way in essentially erasing the impact of child labor, which is to rehabilitate these children who have been forced to work when they shouldn't be. As Kevin had mentioned, child labor does not just lead to losing childhoods. These children work in really difficult conditions, often exploitative environments, and their overall health and nutrition also suffers, leaving them vulnerable to various illnesses. The first step in curbing this incessant rise, especially in the background of a pandemic, is to acknowledge that there is a problem. So we need to accept that no pandemic, no economic crisis, and no extraordinary circumstances can ever justify that children are being exploited. And only then can sustainable change happen. And what happens during this post-rehabilitation rescue is that we can employ various nonprofits, we can employ civil societies that care about children's rights to support them in a psychosocial manner, which means they would run compensation programs for them and take efforts to allow children to not only enroll themselves in school, but also take care of their basic health and nutrition. And perhaps the most important thing that can be done to curb the rise in child labor would be to engage children in education. And this is a proven way to prevent child labor, to essentially ensure that no children are left out in accessing education. And there are many ways in which civil societies and organizations can enable this. So by the way of free schools, or by making sure that even in places where government schools do exist, college students can go ahead and volunteer to teach the children, or make sure that if anybody, if like a child is not being allowed to attend school, that somebody goes and speaks to their parents and explains to them how important it is that the child gains access to education. a lot of unique examples have also come out in the course of the pandemic, where a headmaster in Jharkhand installed loudspeakers at various spots in the village so that children could attend classes from different locations. So even if kids weren't allowed to go to schools, and even if there is no internet connectivity, it has to be made sure that they are learning. That brings me to an end of this presentation. I hope we have been able to prove to you that not only is child labor an important issue that needs to be addressed, especially by those who are young in this country, but also that the government has been vying to make these efforts. However, these legislative efforts can only succeed and can only prove to be effective when citizens are informed and aware about these issues and are making sure that these laws are enforced and in place for the benefit of the children. Thank you.
Thank you so much. On behalf of the Extension Committee of Government Law College, Mumbai, I would like to express our gratitude to our Principal and Organizing Secretary, Dr. Asmita Vaidya, for her continued guidance for the AZADI 75 Awareness Program, along with respected Principal of Lala Lajpat Rai College of Commerce and Economics, without whom this collaboration would not have been possible. I would also like to thank our faculties in charge, Professor Ruta and Dr. Shweta, our field coordinators, Dr. Meenam Saxena, for their continued assistance and support. Last but not the least, I would like to thank the presenting team for their diligent research on child labor laws and regulations in India and presenting it so lucidly. My fellow student managers and under trainees for their role in hosting this program, and all the participants for their presence and contribution towards making this program a great success. To conclude this program, I would now request you all to stand in attention for the national anthem. Before students leave this meeting, I would like to mention that the feedback form link has been shared in the chat box, and it is important that each student fills the form, as this form will also be used for the attendance and for the participation certificates that will be emailed to each student. So general request to all students to kindly fill the feedback form. Thank you.
Thank you all.
Thank you.